From trial court to high court to Supreme Court, finally justice has been given for Manish Sisodia. What are your first comments on this?
Well, obviously, I'm very happy that a person who has spent this long didn't deserve to spend at all that long. I'm more than happy about the legal way in which it has been dealt with. Bail matters are not to be made long, large, big monuments. They are to be seen in a broad brush, prompt manner. The learned judges, despite the busy schedule, heard it and next week delivered judgment. That's the way matters of liberty should be decided. Number 3, they have dealt with the vital issue that the so-called restrictive conditions of 45, which are assumed, that means that you will be perennially in jail and you can never satisfy the conditions, will be trumped, will be overridden when you have excessive delay. There is no 45 which is statutory, which will override the higher constitutional mandate of delay, anti-delay, under Articles 20, 21 and 22. That also they have held. Number 4, I think they have realized that endless documents, some 450 witnesses, some 50,000 documents cannot be the premium or the price for liberty when you are having 8 supplementary charge sheets. So the larger context of these trials has to be understood. And today, at the most, you are a 7-year issue. You are an under trial. Where is the presumption of innocence? So I think it's a thumping torchlight declaration of what is clearly the law. My biggest problem is I hope and trust high courts and trial courts look into this in the spirit in which it is to be meant.
That's the point.
It should not get, as the Supreme Court has rightly said, it need not trouble the Supreme Court in the vast majority of cases which land up here.
As they said,
they land up here because the high courts have nothing to lose, the trial courts have nothing to lose, but their inhibitions.
So do you think they will follow that Supreme Court thing? Because there's a very clear, very strong word saying that,
under articles of the Constitution, 141, 142, all courts, forget courts, every authority, every institution, every human being must follow. But you must follow by letter and spirit. And there is nothing to restrain you or inhibit you. As I said, some little amount of boldness, you only will need to shed some undefinable inhibitions.
And the last point on Arvind Kejriwal, sir, now that you have been also pursuing his case for a long time, do you think he'll get relief?
I don't want to comment on that because I commented on the last one because it's over. Because Kejriwal is sub judice, except to
say... But you're moving his bill.
Of course it is being moved. It will be coming up shortly. But except to say there is a remarkable facet about Kejriwal, which at least I have not found in any major case which I have done. And that is a remarkable facet. We have 3 orders, all 3 I have the privilege of personally piloting, of grant of liberty / bail to Kejriwal under PMLA. Not once, not twice, thrice. Twice by the Supreme Court, once by the trial court has been stayed. I have yet to come across a case where you are released despite Section 45 under PMLA in some form or the other thrice, and you are arrested and found not entitled to bail without Section 45 in CBI arrests.
And Justice Gavai said a very important point to you as he concluded. He says, in matters of personal liberty, every day counts. So do you think...
This is not a question of saying. What I really admire and appreciate about judges is that they've walked the talk. They've not said it, they've actually done it. That is important. Just to say it, just to rhetorically declare it, but they have walked the talk, they've dealt with the matter in a very fair and a very quick and a very comprehensive manner, and they've done justice.
Many congratulations. Here was Mr Singhvi, who has finally been able to give some relief to the Aam Aadmi Party leader, Mr Manish Sisodia, and as he says, he's extremely hopeful even for Arvind Kejriwal, who presently remains in jail as the Delhi Chief Minister.